Question 1. International dispute resolution. During a comprehensive review of a process that needs improvement, two states, Alpha and Beta, are involved in a territorial dispute over a strategically significant island. Alpha claims historical ownership, citing treaties from the 18th century, while Beta asserts that the island belongs to it under the principle of effective occupation. The states initially engaged in diplomatic negotiations but failed to reach a resolution. They agreed to submit the matter to international arbitration under the Permanent Court of Arbitration (PCA). After a ruling in favor of Alpha, Beta refuses to comply, arguing that the tribunal lacked jurisdiction. What is the most legally sound course of action for Alpha to enforce the arbitral award under international law? A. Seek enforcement through the International Court of Justice as it has compulsory jurisdiction over all state disputes. B. Request the Unsecurity Council to impose sanctions on Beta to compel compliance. C. Pursue enforcement through diplomatic means, including state responsibility mechanisms and potential countermeasures. D. Invoke universal jurisdiction under customary international law to enforce the arbitral decision. Answer. C. Pursue enforcement through diplomatic means, including state responsibility mechanisms and potential countermeasures. Explanation. The option A does not have automatic jurisdiction over all state disputes. It only has jurisdiction when states have consented to it under Article 36 of its statute. Since this case was arbitrated under the PCA, the EICH is not the primary enforcement body. The Unsecurity option B does not typically intervene in enforcing arbitral awards unless the dispute threatens international peace and security under Chapter Oman of the UNCharter. Diplomatic measures and countermeasures option C are consistent with the principle of state responsibility under the Articles on Responsibility of States for Internationally Wrongful Acts (ARSUA). Alpha can apply countermeasures, such as suspending treaty obligations or limiting diplomatic relations, provided they are proportional and temporary. Universal jurisdiction option D applies to certain crimes like genocide and war crimes, but not to disputes over arbitral enforcement. Question 2. Law of C. In a high-stakes environment where multiple challenges arise due to overlapping maritime claims, State X and State Y both claim an exclusive economic zone around a disputed maritime area rich in oil and gas. State X argues that its claim is based on the natural prolongation of its continental shelf, while State Y asserts that the median line principle should apply. The dispute escalates when State X begins unilateral resource exploitation and State Y files a case before the International Tribunal for the Law of the Sea (ITLOS). Which legal principle is most relevant in resolving this dispute? A. The equitable principle ensuring a fair allocation based on natural geographic circumstances. B. The territorial sea principle, which determines sovereignty up to 12 nautical miles from a state's baseline. C. The right of innocent passage, ensuring freedom of navigation in another state's territorial waters. D. The archipelagic baseline system, which applies only to island nations recognized under UNCLOS. Answer. A. The equitable principle ensuring a fair allocation based on natural geographic circumstances. Explanation. The equitable principle option A is a fundamental rule in maritime delimitation as established in cases such as Nicaragua v. Colombia (ICH 2012) and Libya v. Malta (ICH 1985). It considers factors such as coastal geography, proportionality, and access to resources rather than simply applying strict median line. The territorial sea principle option B is not relevant here as it governs sovereignty up to 12 nautical miles but does not extend to ease or continental shelf disputes. The right of innocent passage option C under Article 17 of UNCLOS pertains to navigation rights and does not impact maritime boundary disputes. The archipelagic baseline system option D under Article 47 of UNCLOS only to states composed entirely of islands such as Indonesia or the Philippines, making it irrelevant in a dispute between two continental states. Question 3. International criminal law. While analyzing the root causes of sequential problems in international prosecution, a high-ranking military officer, General Z, is accused of authorizing widespread atrocities against civilians, including mass killings, torture, and forced displacements. The International Criminal Court issues an arrest warrant, but the state in which General Z resides refuses to extradite him, citing sovereignty. Under international law, what is the most effective legal mechanism to hold General Z accountable? A. Invoke the principle of complementarity and pressure the state to prosecute General Z domestically. B. Request the General Assembly to override national sovereignty and enforce the arrest warrant. C. Unilaterally authorize a military operation to apprehend General Z under the doctrine of universal jurisdiction. D. Apply for an advisory opinion from the Eich on the legality of the Eich's jurisdiction. Answer. A. Invoke the principle of complementarity and pressure the state to prosecute General Z domestically. Explanation. The principle of complementarity, option A, under Article 17 of the Rome Statute states that the Eich only intervenes when a state is unwilling or unable to prosecute. If the state is capable of trying General Z, the Eich must defer to domestic courts. However, if the prosecution is a sham, the Eich has jurisdiction. The General Assembly, option B, has no direct enforcement authority under the Charter. Only the Security Council under Chapter Roman and refer a case to the G. Darfur, Sudan referral in 2005. Unilateral military action, option C, is illegal under Article 2(4) of the Charter, which prohibits the use of force unless authorized by the UNSC or justified under self-defense. An Eich advisory opinion, option D, is non-binding and does not compel states to act, making it ineffective for prosecution. Question 4. In a high-stakes environment where multiple challenges must be managed simultaneously, a dispute arises between two sovereign states over maritime boundaries and the rights to exploit natural resources within a contested exclusive economic zone. One state claims that historical rights grant it sovereignty over the area, while the other argues that international treaty law, particularly the United Nations Convention on the Law of the Aquarius, supports its claim. Given the complexity of the dispute, both parties consider various dispute resolution mechanisms, including adjudication by the International Court of Justice, arbitration, and diplomatic negotiation. Which of the following is the most legally sound approach under international law? A. The state with historical claims automatically has sovereignty over the contested maritime area, as customary international law recognizes long-standing uses a valid legal basis. B. The dispute should be resolved solely through bilateral negotiations, as international courts lack jurisdiction over state sovereignty disputes unless both parties consent. C. Unclosed provides a legal framework for resolving maritime disputes, and them may be referred to the Eich or an arbitral tribunal for a binding decision. D. The United Nations Security Council has exclusive authority to determine maritime boundary disputes and can enforce a resolution through sanctions. Answer. C. Unclosed provides a legal framework for resolving maritime disputes, and the matter may be referred to the Eich or an arbitral tribunal for a binding decision. Explanation. Under international law, particularly unclosed disputes over maritime boundaries should be resolved through peaceful means, including negotiation, mediation, arbitration, or adjudication by the Eich or the International Tribunal for the Law of the Sea. Eich has ruled on multiple maritime disputes, applying unclosed principles. Historical claims do not automatically override treaty-based rules, and bilateral negotiations alone may not be sufficient if an agreement cannot be reached. The UNSC does not have exclusive authority to settle such disputes, but may intervene if the dispute threatens international peace and security. Question 5. During a critical transition period where existing processes of refugee protection are under scrutiny, a nation implements new laws restricting asylum applications, arguing that an increased influx of refugees poses a security threat. The government enacts a policy that mandates immediate deportation of asylum seekers without an individual hearing, even if they claim persecution in their home country. Human rights organizations challenge the policy, citing violations of international law, particularly the 1951 Refugee Convention. Which of the following statements best reflects the legal obligations of the state under international refugee law? A. The state has the sovereign right to implement immigration policies, including deportation, without considering international treaties. B. Under the 1951 Refugee Convention, the principle of non-refoulement prohibits returning individuals to a country where they face persecution, making immediate deportation unlawful. C. States can refuse asylum to all refugees if they justify the decision based on national security concerns, overriding international obligations. D. The refugee crisis should be addressed by the United Nations Security Council, which has the power to suspend a state's obligations under the 1951 Refugee Convention. Answer. B. Under the 1951 Refugee Convention, the principle of non-refoulement prohibits returning individuals to a country where they face persecution, making immediate deportation unlawful. Explanation: the principle of non-refoulement, established under Article 33 of the 1951 Refugee Convention, prohibits states from expelling or returning refugees to a territory where they face serious threats to life, freedom. The absolute nature of this principle means that security concerns cannot justify blanket deportations without individual assessments. States may regulate immigration, but they must comply with their international legal obligations. The UNS does not have the power to suspend treaty obligations related to refugee protection. Question 6. When implementing new protocols in a shared environment where cyber activities transcend national borders, the government authorizes cyber operations against foreign entities suspected of conducting cyber espionage. The affected foreign state argues that such actions violate international law. The responding state defends its actions under the principle of self-defense. However, international legal frameworks regarding cyber conflicts are underdeveloped, leading to disagreements about the legality of offensive cyber operations. What legal principles govern the use of cyber operations under international law? A. The principle of sovereign equality prohibits cyber operations that interfere with another state's digital infrastructure, making the attack a violation of international law. B. Cyber attacks can be justified under Article 51 of the UN Charter if they amount to an armed attack, but the threshold for defining an armed cyber attack remains unclear. C. Cyber conflicts are not regulated under existing international law, meaning states can freely engage in cyber operations without legal consequences. D. The Tallinn Manual is a legally binding treaty that establishes definitive rules for cyber warfare, making all cyber attacks subject to international criminal prosecution. Answer: B. Cyber attacks can be justified under Article 51 of the UN Charter if they amount to an armed attack, but the threshold for defining an armed cyber attack remains unclear. Explanation: under Article 51 of the UN Charter, a state has the right to self-defense if it suffers an armed attack. However, in the cyber context, defining an armed attack is complex, as cyber operations often fall below traditional military force thresholds. The Tallinn Manual, while an important academic guide, is not legally binding. The principle of sovereignty means cyber operations that cause significant harm to another state may be unlawful, but international law does not yet provide clear-cut answers on all cyber-related disputes. Question 7. During a major transformation where existing methods of enforcing international trade laws are being reconsidered, a country imposes high tariffs on imports from another country, citing national security concerns. The affected state challenges these tariffs at the World Trade Organization (WTO), arguing they violate trade agreements. The imposing state argues that the WTO do not challenge its sovereignty and national security. How WTO address national security exceptions? WTO members have absolute discretion in defining national security concerns, and no other state can challenge such measures. B. Under Article 9 of a General Agreement on Tariffs and Trade (GATT), states may invoke national security exceptions, but the measure must not be arbitrary or a disguised trade restriction. C. The WTO dispute settlement body has no authority to review national security measures. D. National security justifications automatically override other LWU rules, allowing states to impose any trade restrictions without consequences. Answer: B. Under Article 9 of a General Agreement on Tariffs and Trade (GATT), states may invoke national security exceptions, but the measure must not be arbitrary or a disguised trade restriction. Explanation: Article 9 of the GATT allows states to implement trade restrictions for national security reasons, but the measure must be justified, proportional, and not disguised as economic protection. LWU annals have ruled that security cannot be an absolute justification for trade barriers. The WTO review security-based trade measures, and arbitrary restrictions can lead to trade disputes. Question 8. In an environment of intense regulatory scrutiny where financial institutions are reassessing risk management strategies, a multinational bank is accused of failing to implement adequate anti-money laundering (AML) controls. Regulatory authorities argue that the bank's insufficient compliance measures have enabled illicit financial transactions, violating both domestic laws and international standards set by the Financial Action Task Force (FATF). The bank contends that its internal procedures are sufficient under national law and that it should not be held responsible for third-party activities. Which of the following best describes the bank's legal obligations under international AML frameworks? A. Banks are only required to follow national laws, and international AML regulations are non-binding recommendations. B. Under FATF standards, financial institutions must establish robust MI programs, including customer due diligence, CDD, and suspicious activity reporting, regardless of national law. C. Bank cannot be held responsible for illicit transactions if it was unaware of them at the time they occurred. D. Fine. Regulators must prove intentional misconduct before imposing sanctions on financial institution. Answer B. Under FATF standards, financial institutions must establish robust MI programs, including customer due diligence, CDD, and suspicious activity reporting, regardless of national law. Explanation: the Financial Action Task Force (FATF) establishes international AML standards requiring banks to implement risk-based policies, conduct customer due diligence, CDD, and report suspicious transactions. These obligations are regardless of national law, as many jurisdictions incorporate FATF recommendations into binding domestic regulations. A financial institution can be held liable for failing to implement adequate compliance measures even if it did not intentionally facilitate money laundering. Regulators do not need to prove intent. The negligence in compliance is often sufficient for enforcement actions. Question 9. During a significant transformation where technological innovation is redefining workplace operations, a company introduces artificial intelligence (AI) to manage employee performance and productivity tracking. Employees challenge the AI system, claiming it unfairly penalizes workers and violates labor rights. The company argues that AI enhances efficiency and eliminates human bias. Labor unions seek regulatory intervention, citing concerns about transparency and algorithmic accountability. Which of the following best represents global legal approaches to AI-driven employment decisions? AI-generated employment decisions are lawful as long as they improve workplace efficiency and companies are not required to disclose how algorithms function. B. The European General Data Protection Regulation (GDPR) requires employers to provide transparency on AI-driven decisions affecting employees, including the right to human review. C. AI decision-making in employment is entirely unregulated, allowing companies to implement algorithmic tracking without legal constraints. D. Employers can require workers to waive their rights to challenge AI-driven employment decisions in their contracts. Answer B. The European General Data Protection Regulation (EDR) requires employers to provide transparency on AI-driven decisions affecting employees, including the right to human review. Explanation: Under EDR Article 22, individuals have the right not to be subject to fully automated decision-making that significantly affects them, including AI-driven employment decisions. Employers must provide transparency, explain the logic behind AI determinations, and allow human review of automated decisions. While AI enhances efficiency, unchecked algorithmic decision-making can result in bias, discrimination, and unfair labor practices. Many jurisdictions, including the European Union, United States, and Canada, are advancing AI regulation to ensure fairness and accountability in employment. Question 10. When implementing new strategies to enhance environmental sustainability, a multinational corporation introduces carbon offset programs to mitigate its greenhouse gas emissions. However, environmental watchdogs criticize the initiative, alleging that the company continues to pollute while using carbon credits as a marketing strategy to appear environmentally responsible. Regulators begin investigating whether the companies constitute greenwashing, which legal principles apply to corporate carbon offset claims. A. Companies can freely market carbon offset programs without disclosing their actual emissions. B. Environmental laws in many jurisdictions require corporate transparency and sustainability claims to prevent misleading environmental marketing. C. Greenwashing allegations are subjective and have no legal consequences. D. Only government-approved carbon offset projects can be legally advertised, regardless of actual corporate emissions. Correct answer: B. Environmental laws in many jurisdictions require corporate transparency and sustainability claims to prevent misleading environmental marketing. Explanation: Many jurisdictions, including the United States, European Union, and Australia, enforce laws prohibiting deceptive environmental claims. Companies promoting carbon neutrality or offset programs must provide verifiable evidence of their emissions reductions. Regulatory agencies, such as the Federal Trade Commission (FTC) in the US, have issued guidelines to prevent greenwashing, the practice of misleading consumers about environmental benefits. Falsely advertising sustainability efforts can lead to legal action, fines, and reputational damage. Question 11. During a high-stakes negotiation where international trade agreements are being reevaluated, two countries impose retaliatory tariffs on each other's exports, citing unfair trade practices. The dispute escalates to the World Trade Organization (WTO), where one country claims the tariffs violate WTO rules, while the other argues they are justified under the safeguard measures provision. What is the legal basis for safeguard measures at WTO? AWU members can impose tariffs on any imports that negatively affect their domestic industries without restrictions. B. Safeguard measures under Article 6 of GATT allow temporary import restrictions but require economic justification (WTO) ratification. C. Country can unilaterally impose tariffs with WTO oversight if it believes its economy is at risk. DWA dispute resolution procedures do not apply to disputes between sovereign nations. Answer B. Safeguard measures under Article 6 of GATT allow temporary import restrictions but require economic justification (WTO ratification). Explanation. Under Article 6 of the General Agreement on Tariffs and Trade, WTO members can impose temporary safeguard measures if a surge in imports threatens domestic industries. However, these measures must be justified with economic data applied temporarily and report. WTO unilateral tariffs with WTO ratification may lead to trade disputes and countermeasures till the dispute settlement process is legally binding, ensuring trade disagreements are resolved based on established international law. Question 12. In a rapidly evolving financial landscape where cryptocurrencies are challenging traditional regulatory frameworks, a government proposes strict regulations requiring cryptocurrency exchanges to register as financial institutions. Critics argue that these measures stifle innovation, while regulators insist they are necessary to prevent financial crimes. Which of the following best describes the regulatory approach to cryptocurrency? A. Cryptocurrencies operate in a legal grey area, and governments cannot regulate digital assets. B. Many countries, including the U.S. and EU, classify cryptocurrency exchanges as financial institutions, requiring them to comply with UML and consumer protection laws. C. Governments have no jurisdiction over decentralized financial transactions. D. Cryptocurrency exchanges are exempt from financial regulations because they do not handle physical currency. Answer B. Many countries, including the U.S. and EU, classify cryptocurrency exchanges as financial institutions, requiring them to comply with UML and consumer protection laws. Explanation. Cryptocurrency exchanges are subject to regulation in many jurisdictions. The U.S. Financial Crimes Enforcement Network (FinCEN) and European ML directives classify exchanges as financial institutions, requiring compliance with anti-money laundering (ML) laws, know your customer (KYC) rules, and consumer protections. While cryptocurrencies themselves may operate decentrally, governments regulate exchanges, trading platforms, and financial intermediaries to prevent fraud and illicit activities. Question 13. When navigating complex challenges in corporate governance where ethical decision-making intersects with legal obligations, a publicly traded company faces scrutiny over its board of directors' failure to disclose conflicts of interest. Shareholders claim that key executives approved contracts benefiting their personal business interests, violating fiduciary duties. The company argues that its board followed proper internal procedure, and that no laws were broken. Which of the following best represents the fiduciary duties of corporate directors? A. Corporate directors are free to approve contracts that benefit them personally as long as they are disclosed to shareholders. B. Fiduciary duties require directors to act in the best interests of shareholders and disclose potential conflicts of interest. C. Directors are only liable for conflicts of interest if a court proves they acted with criminal intent. D. Shareholders have no legal right to challenge board decisions as corporate governance, dictated solely by internal policies. Answer B. Fiduciary duties require directors to act in the best interests of shareholders and disclose potential conflicts of interest. Explanation. Corporate directors owe fiduciary duties of loyalty and care to shareholders, requiring them to act in the company's best interest and avoid conflicts of interest. Failure to disclose conflicts can lead to legal liability, shareholder lawsuits, and regulatory penalties. Most corporate laws include, under the Sarbanes-Oxley Act (US) and UK Companies Act, mandate full disclosure of conflicts. Courts do not require proof of criminal intent. Negligence or failure to act in good faith can suffice for legal consequences. Question 14. Amid rapid advancements in artificial intelligence where automation is transforming decision-making processes, a technology company implements an AI-driven hiring system. The system is later found to disproportionately reject applicants from certain demographic groups. Advocacy groups claim that AI violates anti-discrimination laws, while the company argues that the algorithm is neutral and was not programmed to discriminate. What legal principles govern AI-based hiring discrimination? AI-driven hiring decisions are lawful as long as they increase efficiency, regardless of outcomes. B. Employers are legally responsible for ensuring AI hiring systems do not result in discriminatory outcomes, even if unintentional. C. Anti-discrimination laws do not apply AI-based hiring decisions because they are not made by humans. D. AI hiring systems cannot be challenged legally unless discrimination was intentional. Answer: B. Employers are legally responsible for ensuring AI hiring systems do not result in discriminatory outcomes, even if unintentional. Explanation: under laws like the U.S. Civil Rights Act, Title Omen, and EU General Data Protection Regulation GDPR, companies must ensure AI hiring tools comply with anti-discrimination standards. The concept of disparate impact holds employers accountable for AI-driven decisions that result in unintentional discrimination. Even if an algorithm is designed to be neutral, biased training data or flawed logic can lead to discriminatory outcomes, making employers legally liable. Regulators are increasingly scrutinizing AI in hiring, requiring algorithmic transparency and fairness assessments. Question 15. In a competitive global economy where international tax structures are under increasing scrutiny, a multinational corporation is accused of shifting profits to low-tax jurisdictions to minimize its tax liability. Governments argue this practice erodes national tax bases, while the company claims it is following all legal tax codes. Which international tax principle applies to profit shifting? A. Companies have an absolute right to minimize taxes using any available legal strategies. B. Guidelines on base erosion and profit shifting (BEPS) aim to prevent artificial profit shifting through tax avoidance schemes. C. Tax laws only apply within national borders, making international profit shifting legally untouchable. D. Countries cannot challenge corporate tax strategies as long as businesses disclose their tax filings. Answer: B. Guidelines on base erosion and profit shifting (BEPS) aim to prevent artificial profit shifting through tax avoidance schemes. Explanation: the base erosion and profit shifting (BEPS) framework was developed to combat tax avoidance by multinational corporations. It ensures profits are taxed where economic activity occurs, rather than in jurisdictions with low or zero tax rates. Many countries have adopted BEPS reforms, including stricter transfer pricing rules, country-by-country reporting, and corporate tax transparency requirements. While companies can engage in tax planning, aggressive profit shifting violates the spirit of fair taxation and is increasingly subject to regulatory enforcement. Question 16. As nations grapple with data privacy concerns where consumer protection is paramount, a social media company faces regulatory action for allegedly mishandling user data. The company claims that users consented to data collection through its terms of service, but regulators argue that the consent process was deceptive and non-compliant with privacy laws. Which legal framework is most relevant to this case? A. Companies can collect and use any consumer data as long as they provide a terms of service agreement. B. The General Data Protection Regulation GDPR requires companies to obtain clear, informed, and freely given user consent for data processing. C. Privacy laws do not apply to social media platforms because users voluntarily share their data. D. Regulators cannot challenge data collection practices unless they result in financial harm to consumers. Answer: B. The General Data Protection Regulation (GDPR) requires companies to obtain clear, informed, and freely given user consent for data processing. Explanation: the General Data Protection Regulation (GDPR) establishes strict consent requirements for data collection, requiring it to be explicit, informed, and freely given. Companies cannot use deceptive or vague consent forms. Regulators such as the European Protection Board (EPI) in U.S. Federal Trade Commission (FTC) increasingly enforce privacy laws to prevent unauthorized data exploitation. Non-compliance can result in severe fines and reputational damage. Question 17. As financial institutions adapt to an evolving regulatory landscape where digital assets are gaining mainstream acceptance, a major bank integrates cryptocurrency services. However, regulators warn that cryptocurrencies facilitate illicit financial transactions, raising compliance concerns. What is the primary regulatory concern with cryptocurrency integration in banking? A. Cryptocurrencies are unregulated and cannot be subject to compliance requirements. B. Regulators focus on anti-money laundering compliance, requiring banks to monitor and report cryptocurrency transactions. C. Banks are prohibited from dealing with cryptocurrency due to legal uncertainty. D. Cryptocurrencies operate entirely outside legal frameworks, making regulation impossible. Answer: B. Regulators focus on anti-money laundering compliance, requiring banks to monitor and report cryptocurrency transactions. Explanation: banks integrating cryptocurrencies must comply with laws, know your customer, CAPE rules, and financial reporting requirements. The Financial Action Task Force (FATF) has introduced travel rule requirements mandating banks to track and report large digital asset transactions. Failure to comply can result in heavy fines and legal action. Question 18. While analyzing the root causes of sequential problems in a manufacturing process where delays are increasing, a quality assurance team discovers that different assembly lines follow slightly varied protocols, leading to inconsistent outputs. Workers report that these deviations were introduced to accommodate different machine tolerances, but now defects have increased. Which of the following actions would best resolve this issue? A. Standardizing all assembly line procedures to ensure identical outputs regardless of individual machine differences. B. Conducting a detailed process analysis to determine whether the variations improve or hinder quality, then adjusting procedures accordingly. C. Replacing all machines with identical models to eliminate tolerance differences. D. Allowing each team to continue with their own optimized version of the process to maintain flexibility. Correct answer: B. Conducting a detailed process analysis to determine whether the variations improve or hinder quality, then adjusting procedures accordingly. Explanation: standardizing procedures may seem ideal, option A, but it ignores real-world machine variations, which can result in inefficiencies. Replacing all machines, option C, would be costly and unnecessary, allowing teams to maintain individualized approaches, option D. Long-term inconsistencies. The thorough process analysis, option B, allows the company to identify beneficial variations versus harmful inconsistencies, enabling a data-driven decision for process improvements. Question 19. During a comprehensive review of a process that needs improvement in a logistics company, it is discovered that package tracking updates are frequently delayed, leading to customer dissatisfaction. The team suggests implementing a new real-time tracking system, but the operations team is concerned about the cost and technical challenges. What should be the first step in resolving this issue? A. Conducting a feasibility study to evaluate the costs, benefits, and technical requirements of a real-time tracking system. B. Implementing the new system immediately to address customer complaints. C. Keeping the current system and instructing customer service teams to handle complaints more efficiently. D. Outsourcing tracking updates to a third-party provider to avoid internal system modifications. Answer: A. Conducting a feasibility study to evaluate the costs, benefits, and technical requirements of a real-time tracking system. Explanation: a feasibility study, option A, ensures that all departments understand the trade-offs between cost, complexity, and improved performance. Immediate implementation, option B, might be premature without understanding infrastructure needs. Relying solely on customer service, option C, does not solve root problem. Outsourcing, option D, could be costly and introduce dependencies. A structured evaluation ensures the best long-term solution. Question 20. When developing a solution that must address opposing needs in a project, a software team faces a dilemma. Customers demand increased security, but performance metrics drop when stricter encryption is applied. The product team must decide on a balanced approach. What is the best course of action? A. Optimizing encryption algorithms to maintain security while minimizing performance loss. B. Removing encryption on non-sensitive data to improve performance. C. Increasing server capacity to offset the performance drop regardless of cost. D. Prioritizing security at all costs even if performance becomes unacceptable to users. Answer: A. Optimizing encryption algorithms to maintain security while minimizing performance loss. Explanation: balancing security and performance is key. Option A ensures optimization while maintaining safety. Removing encryption, option B, may expose vulnerabilities. Increasing capacity, option C, could be too costly. Prioritizing security at the expense of usability, option D, could lead to customer dissatisfaction. Optimizing encryption algorithms provides a practical middle ground. Question 21. In an environment where different components must interact seamlessly, a telecommunications company deploys 5 grams infrastructure but faces unexpected latency issues when integrating with older 4 grams networks. Customers report inconsistent data speeds. What is the most effective way to resolve this? A. Developing adaptive network protocols to optimize 5 grams to 4 grams transitions. B. Phasing out 4 grams networks immediately to force full 5 grams adoption. C. Asking customers to manually switch between 4 grams and 5 grams networks as needed. D. Reducing 5 grams coverage to minimize interference with 4 grams networks. Answer: A. Developing adaptive network protocols to optimize 5 grams to 4 grams transitions. Explanation: seamless interaction between different network generations requires adaptive protocols. Option A. Phasing out 4 grams. Option B is impractical as many customers still rely on it. Manual switching. Option C is inconvenient. Reducing 5 grams coverage. Option D undermines network expansion efforts. Question 22. When scaling up operations that experience significant variations in demand, a retail chain faces stock shortages in some locations while overstocking in others. Predictive analytics tools are suggested as a solution. What should the company prioritize? A. Implementing a data-driven inventory management system that adjusts based on demand forecasts. B. Keeping current ordering methods to maintain consistency. C. Increasing stock levels everywhere to avoid shortages. D. Reducing product variety to simplify inventory management. Answer: A. Implementing a data-driven inventory management system that adjusts based on demand forecasts. Explanation: predictive analytics can optimize stock levels dynamically. Option B resists necessary improvements. Option C wastes resources, while option D limits customer choices. A demand-driven system ensures efficiency. Question 23. In a high-stakes environment where multiple challenges arise simultaneously, a financial institution experiences a cyber attack while also managing a system outage, creating uncertainty for customers. What should be the first response? A. Isolating affected systems and activating an incident response plan to minimize damage. B. Announcing to the public that services will be restored without explaining the issue. C. Shutting down all operations until a full investigation is complete. D. Addressing customer complaints first, then handling the cyber attack. Answer: A. Isolating affected systems and activating an incident response plan to minimize damage. Explanation: a structured response plan, option A, minimizes damage and ensures both issues are managed simultaneously. Option B lacks transparency. Option C disrupts services unnecessarily, and option D delays security actions. Question 24. While examining inconsistencies across various units in a multinational company, leadership finds that regional offices follow different reporting formats, making global analysis difficult. What is the best approach? A. Implementing a unified reporting framework while allowing regional flexibility where necessary. B. Forcing all offices to use a single rigid format immediately. C. Allowing regional offices to continue using independent methods. D. Relying on manual data reconciliation. Answer: A. Implementing a unified reporting framework while allowing regional flexibility where necessary. Explanation: a hybrid approach balances standardization with flexibility. Rigid enforcement, option B, can be impractical, while option C perpetuates inconsistencies. Manual reconciliation, option D, is inefficient. Question 25. During an emergency response where multiple areas are impacted by a severe weather event, disaster relief teams struggle with coordination due to differing regional policies. What is the best solution? A. Developing an integrated emergency response system with standardized protocols. B. Letting each region handle its own response separately. C. Relying solely on local governments without national coordination. D. Delaying response efforts until a full assessment is complete. Answer: A. Developing an integrated emergency response system with standardized protocols. Explanation: standardized protocols improve coordination across regions. Option B and C reduce efficiency, and option D delays critical aid. Question 26. In a situation where formal requirements conflict with practical constraints a software development team working on a government contract must meet strict cybersecurity regulations while also ensuring user-friendliness. The compliance team insists on additional security measures that slow down the application, frustrating the design team. What is the best way to resolve this conflict? A. Conducting a structured risk assessment to balance compliance needs with usability requirements. B. Prioritizing full compliance, even if it makes the application difficult to use. C. Removing security measures selectively to improve user experience. D. Asking users to manually override security settings when needed. Answer A. Conducting a structured risk assessment to balance compliance needs with usability requirements. Explanation. Option A allows for a systematic evaluation of risks, ensuring both security and usability are optimized. Strict compliance at the cost of usability. Option B may lead to poor adoption, reducing security arbitrarily. Option C increases vulnerabilities, allowing manual overrides. Option D defeats the security control. Question 27. When implementing backup procedures across various departments, an organization realizes that each team uses different methods for data storage and recovery. Some rely on cloud-based backups, while others use local servers, causing inconsistencies in recovery times. What should be the best approach? A. Developing a unified backup strategy that incorporates both cloud and local solutions for redundancy. B. Forcing all teams to adopt a single backup method, regardless of their needs. C. Allowing each department to continue its preferred method without central oversight. D. Eliminating local backups and relying exclusively on cloud storage. Answer A. Developing a unified backup strategy that incorporates both cloud and local solutions for redundancy. Explanation. A hybrid approach. Option A ensures redundancy and flexibility. Option B may not suit all teams. Option C maintains inefficiencies. And Option D creates a single point of failure. A well-integrated backup system enhances reliability. Question 28. During a major transformation where existing methods are being replaced with automation, a manufacturing company faces resistance from employees concerned about job security. Productivity gains are evident, but morale is declining. What is the best way to address this situation? A. Providing employees with retraining opportunities to transition into new roles created by automation. B. Proceeding with automation without addressing employee concerns. C. Slowing down the automation process to maintain existing jobs. D. Ignoring productivity gains and reverting to manual processes. Answer A. Providing employees with retraining opportunities to transition into new roles created by automation. Explanation. Investing in employee retraining. Option A ensures workforce adaptation while maintaining productivity. Option B disregards morale. Option C hinders progress. And Option D is regressive. A proactive approach secures both business success and employee growth. Question 29. While updating traditional approaches where interconnections between departments are critical, a hospital introduces a new digital patient record system. However, different departments struggle to adapt due to workflow differences, leading to errors and delays. What should be prioritized to resolve this issue? A. Conducting cross-departmental training and iterative system refinements based on feedback. B. Requiring immediate system adoption, regardless of staff concerns. C. Allowing each department to maintain its own record-keeping methods. D. Reverting to paper-based records to simplify operations. Answer A. Conducting cross-departmental training and iterative system refinements based on feedback. Explanation. Comprehensive training and iterative adjustments. Option A ensure a smooth transition, forcing immediate adoption. Option B can create resistance, maintaining separate systems. Option C undermines integration while reverting to paper. Option D negates the benefits of digital transformation. Question 30. During the introduction of new methods where coordination across teams is required, a global corporation shifts to an agile project management framework. Some teams embrace the change while others struggle with the decentralized decision-making process. What is the most effective way to ensure a successful transition? A. Providing tailored agile training and a phased implementation plan to support teams at different readiness levels. B. Forcing all teams to adopt agile immediately, regardless of their concerns. C. Allowing teams to continue using their previous management styles indefinitely. D. Returning to the traditional project management structure to avoid disruption. Answer A. Providing tailored agile training and a phased implementation plan to support teams at different readiness levels. Explanation. Gradual adoption and targeted support. Option A, maximize engagement and success. Option B overlooks readiness differences. Option C leads to inconsistency, and option D negates progress. A structured approach ensures smooth transformation.